Got it. Hello, hello, hello. Welcome to Murray's Law. I am connecting live on all the other places. And we're getting ready to get started as soon as YouTube gives me the okay. I have something in my eye. Hello, hello, hello. Welcome to Murray's Law. Boom. All right. I have the okay. We are going live. How are you doing today? Welcome, everyone. It is the second Monday of the month, which means we are live for Murray's Law. I'm super duper excited to have you join me live. Today's topic is a really good one, especially considering that there was a lot of pivoting and shifting and just building and growing of businesses and brands over the last 2 years as a result of the pandemic. People realized that in order to better serve their community and their customers, they needed to show up a certain way. Shoot, some people just made the pivot in order to serve themselves better, and that's okay. That's okay. So we are going to check the, here we go. So we're live in all of the places. So for anyone that is new, if you're not familiar with me, I am attorney LaConya Murray. I'm the owner of Mark IP Solutions, where we help innovative entrepreneurs build their brand, grow their businesses, own their genius through trademarks, copyrights, and contracts. Right now, we're streaming live from the Genius Lounge, which is our free community. So if you're watching on Instagram, if you want to be able to watch this replay, or even submit questions, you want to do that in the Genius Lounge, because that's where this question came from. So today's question. And before we get started, let me just do our disclaimer. Murray's Law is a live Q&A session. It is for educational purposes only. This is not legal advice. If you need legal advice, please contact an attorney. If you want to contact me for legal advice, you can do that by scheduling a consultation. Okay, so let's get into this question. The question is, I don't even have the question. The question is, how does me changing my business affect my trademark? So how does changing my business affect my trademark? And I think that, again, that's a really great question. And to make sure you have a great understanding of this question and what it entails, let's just make sure you have an understanding what trademarks are. So trademarks protect brand identifiers. Those brand identifiers are those things that help consumers readily identify the source of a good or a service. The source of a good or a service. We talk more about brand identifiers in episode 91 of the Own Your Genius podcast. But so that's what trademarks protect. And when you have a registered trademark, a federally registered trademark, it allows you the right to prevent other people from using that same or similar brand identifier or trademark in the same or related way. So there's some limitations to your protection. So, and the main thing you need to know is when you have a registered trademark, it does not prevent you from telling everyone everywhere that they cannot use that mark. That's the important thing that I want you to know. A lot of people do not understand that. They think once I get this one trademark, I'm good and set for life. And it doesn't work that way. You don't receive or have that type of authority until you've had your brand for years and invested millions of dollars into creating this global brand that people recognize. And then you can have the argument that if someone else was using your mark, no matter what it's for, then it would diminish the value of that brand, right? So there's limitations on your trademark. So that's why it's really important to understand how you're using your trademark, how you plan on using that mark when you file for registration, because you're going to have to say how you're using this mark. Now, what tends to happen with businesses, we grow, we expand, we pivot, which means when we do those things, the way that we use that trademark changes. And the way that we use those trademarks, those are called classes. So classes are the goods or the services that we've used to identify how we're using that mark. So there are a total of 45 international trademark classes. 1 through 34 are for goods, physical products. 35 through 45 are for services. Services are non-physical products. They're more like activities that we provide to other people. It's a good way of saying it. Activities that we provide for other people. So the majority of the trademark protection that's for class is for goods. And then you have a small section for services. And what that looks like, so a lot of people don't, when it comes to classes, what that looks like. And I have an example here. Let's say you are in the clothing business. You have a t-shirt line, right? That class for the t-shirt line is class 25. But you don't just manufacture the t-shirts or sell the t-shirts. You can have different ways to do this, right? You can have the t-shirt brand and you can have them in stores, and the stores can sell them for you. And you sell them wholesale, right? Or you can have your online store. Most of the people that I work with, they have their own online store. So you have class 25 for your apparel. And that means that this shirt here is branded by, I don't even know, I should have looked beforehand, but whoever is the manufacturer of the brand for this, that's a good. This is a good, right? But when I went to buy it, I bought it from a store. The selling of this is a service. That's a different class. So right now we're dealing, so if you have a branded apparel line, that's one brand. If you're selling it, that's one class. If you're selling it, that's a second class. Now, if you've grown in business and you say, you know what, I really want to make a pivot. I want to get away from the branding, the making, the manufacturing of the apparel. I want to get away from the selling of it. It's just something I don't want to do anymore. Our customers are better served as they need if we do pivot. And so we're going to pivot to online courses, right? If you made the decision to no longer offer your apparel line, now that the way that you registered your trademark, you originally registered for class 25 and 35 for the apparel line and for the selling of that apparel line, and now you're not doing that. Now your trademark is no longer in use. And you can let me know in the comments if this is making sense to you. Let me know in the comments if this is making sense to you. But right now, if you are no longer using those two classes, you're no longer selling your shirts or making your shirts, you're not using it. And after 3 years, it's considered abandoned. That means that registered trademark that you have is not going to be any good because you're not using it. Trademarks are only good if they're connected with a good or a service. If you're no longer offering the good or a service, then it's not any good. You with me? So the pivot is going to put you in a new class, which means that in order to be protected in this new class, because it's not related to what you were doing before, it'll be different if you went from maybe selling t-shirts to selling hoodies or something else that's in that same or related field, right? But you're going to courses. And why I say that is because your protection is limited to same or related mark in the same or related industry or use. So when you go to courses, it's not the same anymore. It's not the same anymore. So what that means is that you will need to file a new trademark application for this new use. Everybody got it? So that's if you make a pivot. Now, sometimes people, they add, so it's not so much of a pivot, but they're growing, they decide to add an additional offering. So let's say you are keeping your apparel line, you're going to keep selling it, but you see a need also for, because people keep asking you, like, how do you do this? How do you do that? This, that, and the other. And so what you decide to do is create a course. So you're still keeping your original use, but now you're also adding additional service. So what does that mean? Since you already have a registered trademark, does that mean, what does that mean? So what that means is if you want your course to be protected, it's going to be branded the same way, and you want protection for that online course, you're going to have to file a new trademark application for that new use, because right now it's not protected by your original trademark, because your original trademark is for 2 other classes. That was a really, really great question. And what we see is because of the limitation on the protection that trademarks have, as far as your protection being limited to how you use it, that's why you have multiple classes. That's also why you have the need for multiple trademarks. So in addition to you having several different types of brand identifiers, oftentimes as your business grows or even pivots, you need additional trademark protection to protect that new use. If you go back and listen to episode 91 of the Own Your Genius podcast, we talk about the need for multiple trademarks. So I'm not going to rehash it here because I've already rehashed it. So go back and listen to episode 91 of that. We only have a few more minutes left in today's session. So I want to get into, so that was a good question. That was a question that was submitted to the Genius Lounge. If you have not joined the Genius Lounge, make sure you do so. And you can do that at thegeniuslounge.co, thegeniuslounge.co. It's free. It's free. And now we're going to get to, there was a lot of interest in the Morris Day and the Prince Estate situation. There's a lot of drama going on there, and I just wanted to kind of give a little bit more information. I've done a couple of reels on it, but I just want to give a little bit more information and background on that as soon as I find out what I did with it. And I found it. Okay, so like I said, this is what I understand the situation to be. I'm not privy to any contracts that they've had drawn, any agreements, because I wasn't in the room, but just from the different articles that I've read, this is what it is. First of all, we know that Prince created the Time back when he was first signed. That was the band that he created. And he invited these different artists to be a part of the band. So you have the band, and you have Morris Day, who was the lead singer. Now, they said when the group first started, even though when they were out, they had a band of 7 playing the instruments. When they did their first album, Prince played every single instrument in that recording, every single instrument. So there was no other people. He played every single instrument. He basically was the Time. And Morris Day was the lead singer, but he was restricted in how he can perform. He had to do it exactly as Prince did it. That's that, but to me, I feel like that's on brand for Prince. Anyway, so this was back in 1981. We're going to fast forward to 2000. What is it? Like 2004. I don't think I have it here. Like 2004, the band had already, the original 7 had already left. They've had members in and out, in and out, in and out. So the original 7 got together. They decided that, hey, we're going to put an album out together. They were advertising, they were on different shows. They were going to put an album out together. And right before they released that album, Prince sent them a cease and desist letter. And rather than fight about it, they went ahead and just changed their name to the original 7. So what that tells me is that there was some type of understanding between the parties. And the Prince's Estate Act says they actually have a written agreement with Morris Day and Prince, where he's acknowledging that Prince owns the name, owns the brand, the Time. Even though Prince allowed him to perform under that name all these years, which is typical. I always tell you when it comes to trademarks, it's just not a sheet of paper. It's not just a certificate. It is something that you can actually create additional revenue from. And so what it sounds like is that Morris Day had a licensing arrangement with Prince. And then when he passed away, literally 14 days after he passed away, he filed a trademark application for Morris Day and the Time. Seems to me that if you're going to wait for someone to pass away, you might have known that you didn't have the rights to it. But we don't know what the agreement says. We don't know if that agreement is limited to Prince's lifetime. And we don't know who said, hey, while I'm here, it's mine. If something happens to me, it's yours. We do not know. I do not know. That could very well be the understanding, but I don't know. What I do know is that he filed the application. He was approved for registration. He had the mark for 4 years. And then last month he surrendered it. and then it was canceled. And then a week after it was canceled, he went on social media and said that Prince's estate told him that he couldn't use it anymore. Which gets to my main point again. So I've talked about a lot of points as it relates to trademarks, but the main thing, one of the things I want to tell you is that trademarks are assets. Trademarks are assets that can be bequeathed. So when you pass away, if someone passed away, when the trademark owner passed away, the rights don't die with the owner. They get passed on. In this case, because Prince did not have a will, it went to his estate. Companies, when the owners die, they stay with the company. While you have some brands, some companies that have been around for decades after the death of the original founder. So that's something that you need to, let me see, there we go. That's something that you need to keep in mind. Now I'm going to see, because we only have a few more minutes left. But anybody have any questions? And let me know if you're watching on any of the platforms, just let me know that you see me. Okay, I see the hearts on Instagram, so that lets me know that you're understanding what I'm saying, that you hear me. Good, good, good. So the main thing that you want to take away from this Morris Day situation is, again, contracts, people, contracts. You can't write a contract or sign a contract that says that someone owns the IP and then come back and try to file a trademark for it yourself when they pass away. You have to read and understand your agreements, which I understand. I understand in the 80s, there weren't conversations like this happening in the 80s. There weren't conversations with people openly talking about intellectual property and what they meant and what you can do and things of that nature. So I can understand how so many people back then, especially in the music industry, were taken advantage of as it relates to IP. But today, way too many resources for that to happen. Way too many resources for that to happen. Okay, so that is today's, we answered the question. I will open the floor for more questions. So just as a recap to the original question, which was, how does changing my business affect my trademark? If you change your business to add more classes, you will need to file a new trademark registration because your trademark protection is limited to how you use it in those initial classes, which we talked about. If you decide to, when you're making this change, instead of adding new services, you take away services, you actually need to file to have those classes removed and then add the new one. Because now they're doing legal audits when we do our renewal, our Section 8 maintenance. And if you go to our blog, we talk more about the maintenance that you have to do in order to maintain your registration. It's not like a one and done thing. Again, with trademarks, you have to use them in order for them to be valid. So USPTO is like, I need to know if you're using this mark. And they do check. They will check 5 years after your initial registration, and then 10 years after that initial registration, and then 10 years, every 10 years after that. So when you're doing that proof, if you have stopped using something, a class, you need to let them know, preferably now before you file that maintenance. All right. Well, cool beans. I'm excited. I'm glad that you all joined me this Monday, the second Monday of the month. We do this every second Monday of the month. Every second Monday of the month at 7 p.m. Central Time. You can join me live and I will answer a question. These questions are pre-submitted from the Genius Lounge. So if you're not a Genius Lounge member, go and join the Genius Lounge at geniuslounge.co. When you go into your dashboard, it's going to have a section that says submit your Murray's Law question here. You're going to, yes, you only see one. So if you are a Genius Lounge member, you'll see it. And even if you're a Genius Insider, you'll see that as well. And our Genius Insiders do take priority. The Genius Insider are the members of our legal subscription program. So absolutely, if you're interested in the Genius Insiders, definitely let me know if you're looking for ongoing legal support for your business. That's something that we can definitely help you with. All right. That's all I have for you this evening. You all have a great one, and I'll talk to you. I'll see you before next month, but we'll do this again in April. Take care.